Some fast-moving developments this week in the ongoing debate over restoring felons' rights to vote in the state of Florida. This week was supposed to be the deadline for Governor Rick Scott and the state's clemency board to craft a new plan for restoring voting rights. That was after a federal judge in Tallahassee ruled the current plan was unconstitutional. After calling a last-minute emergency meeting on Thursday, a federal appeals court stepped in, putting everything, including the voting rights of more than 1.6 million potential voters, on hold. I believe that meeting was on Wednesday night, by the way. But anyway, joining us once again this morning to explain where everything stands and get a little further into this, News Channel 8 legal analyst, former Hillsborough County prosecutor Felix Vega.
Good morning, Evan.
Good morning to you, Felix. All right, first question. Let's start with the meeting that the governor was scheduled to have. What were they planning to do, and why did the appeals court step in?
They released a plan really last minute. They scheduled this for 9:30 on Wednesday night. They ended up not doing it because the appeals court did step in. Right. One of the things they were not going to change, those 70 classified felonies or types of classes of felonies that they were going to, they put you in the 7-year waiting list. You see some of them here as we look through these. And this was not going to change at all. The only thing that they were going to change, according to the draft report I saw, was they were going to change the amount of time they had to make a decision on felon voting rights. They ended up not having to do that. The 11th Circuit came in. They decided they were going to step in on this appeals process that was already going. They granted a stay. We've heard that term a lot lately. Right. And basically, they put everything on hold. Right. The plan to to come up with a new plan, they said, hold on, wait a second. They actually basically relied on a 1969 Supreme Court case that said this whole scheme, the whole plan that's in place, was constitutional under the 14th Amendment. And they actually went a lot into the facts of the case and actually kind of made a ruling ahead of time that's favorable to the state, saying that they do have the right to have this plan in place, and that under this 14th Amendment, states do have the right to take away voting rights of felons. However, it's silent on how long that process is. That's at the heart of this entire case, not only the constitutionality of it, but the fact that it takes so long to get a decision under the discretion of that board. And you see the board only meets 4 times a year in Tallahassee. They found that was burdensome. Right. And you only get 10 minutes, 5 minutes for you, and 5 minutes for anyone that you want to testify on your behalf.
Right. Very interesting there. And it's important to note those felonies that were listed there, you cannot have your felon voting right, your voting rights restored.
You have to wait for 7 years in order to even apply, and that's 7 years after your sentence is already completed. There's a 5-year waiting period for all the other types of felonies that are out there. But then again, the board only meets 4 times a year in Tallahassee. They have that 10-minute hearing. So that's really where the crux of this all is. And then you look at what are the other things that the board can consider. Like, that's the discretion of the board as well. These are some of the issues. Drug or alcohol use since your release. The applicant voted illegally since their release. That came up in one of the examples they were relying on. The Judge Walker was relying on in Tallahassee in order to say that this whole system is really prejudiced against people and it's biased against them on many different terms. And so that's what they're looking at in terms of those types of things. They look at your family life, your attitude, whether or not you're showing remorse during the hearing. All these discretionary things that if one person says the wrong thing, according to the court, that could prevent them from having their voting rights restored because it's in the sole discretion of the governor and the clemency board. Yeah, a ton of power for him, and that's one of the things that the court took issue with, right? So that is what the board, some of the things they can consider, some of the other things they consider. Let's talk about the federal judge in Tallahassee saying that all of that was unconstitutional and ordered the governor to come up with the new plan. Walk us through the reasons why he did that. So basically, they found it unconstitutional for several reasons. One, he said it disenfranchises felons based on race. It was politically motivated. I thought it was interesting because he described this as a case of first impression for one simple reason. The Supreme Court has ruled on voting rights cases before, but they look at the right to vote in the broader context. He actually went inside what is in your right to vote. Things like the free speech, freedom of expression, your right of free association. And this is a really interesting thing because he viewed the people gathering together, binding together in order to support a candidate. Those are all things that were taken away by your right to vote. And so he divvied it up into those 3 different things, said it was unconstitutional under the First Amendment, but also under the 14th Amendment because it violated your due process rights, that there was no uniform way to have your rights restored, and also equal protection because it excluded those 1.6 million voters or potential voters and put them in a different category. Yeah, so we obviously, let's take a look at some of the explicit things that he said. Right, and it's important. I read these these court cases all the time. I like to show the viewers what's inside the reasoning of the judge. This was a couple of the quotes I pulled from it. Florida's vote restoration scheme is crushingly restrictive. It crumbles under strict scrutiny. That's the highest level of review for any court, especially on these issues. He pointed out the potential political, racial, or religious biases cannot poison the well of voter restoration, taking square aim at the governor and the officials. Some of the other ones that he called into place. What's more, plaintiffs offer more than enough examples for this court to infer that such discrimination is not some cockamamie idea the plaintiffs cooked up. That's in direct response to the state. On their appeal, they were actually saying that these some of these accounts were made up. And then this was interesting as far as the length of the process, that indefinite can kicking is not some Floridian fairy tale like a lineless space mountain.
Right.
So
in other words, you can't just kick it on down the road and let it take this long.
There were examples where people were waiting sometimes 11, 12, 20 years to get their rights restored. And so the judge really took a strong stance against it. It's now up on appeal, and the appeals process will take its play out. But then there's also the amendment that's still pending that Mike Vasalinda talked a little bit about. What's going to be interesting is if the case is up on appeal and it's not decided before the amendment possibly passes on the ballot in November, then the Supreme Court is going to have an interesting time reconciling the fact that the voters have restored the rights of 1.6 million people. Are they now going to go back and take it away if they decide to side with the governor, who could be our next U.S. Senator from the state of Florida?
It could be. Obviously a big race there. And it really just depends, courts tend to give voters discretion.
That is, and a lot of it, they're not going to, it'd be very hard pressed for them to go in and take away that right once it's been restored by the will of the people.
Absolutely. Great stuff. Legal analyst and former Hillsborough County prosecutor Felix Vega. We'll be right back, folks.